So here we are, day 22. We've got to knock this out in 2 days, 3 days maybe. But now, what this one is about, day 22. Day 22. How to move a frozen case without becoming the problem. The art of creating movement while appearing compliant. If your case feels stuck, it's not because no one knows what to do. It's stuck because doing nothing is safer than doing something. And today, I'm going to show you how cases actually move forward in family court without you being labeled difficult, hostile, or high risk. This is the part no professional ever explains to you. Because once you understand it, guess what? You stop begging for progress. You start engineering it. And this is the truth about no progress. When professionals say, we're waiting, it's too early, we need more time, the court will deal with it later. What they actually mean is moving this now could create exposure to appeal, complaint, hindsight criticism, safeguarding review, professional embarrassment. So they don't move, not because they can't, because they won't. The mistake everyone makes at this stage is parents think that movement comes from stronger allegations, louder objections, more evidence, more emails, more urgency. That is exactly backwards. Those things increase perceived risk. And the risk is what freezes cases. The rule you were never taught. This is what you were never taught, yeah? In family court, the person who creates the least professional risk gets listened to the least risky. Once you understand that, everything changes. How movement actually happens. So cases move when a professional realizes doing nothing now might look worse later. Your job is not to accuse. Your job is to make inertia uncomfortable quietly. You do this by asking procedural questions, not moral ones, referencing guidance, not injustice, framing concerns as clarification, not criticism, making future review visible without threatening it. You don't push the system, you let it see itself. The most powerful sentence in family court, and no one will teach you this. Here it is. Pay special attention. Write this down. Use it carefully. I'm trying to understand how this current position would be explained if this case were reviewed in the future. That sentence isn't an accusation, isn't emotional, isn't hostile, isn't confrontational, but every professional in the room hears it. And this is what they hear. This file may be examined later. That is movement. And why this terrifies the system. Family court is obsessed with retrospective justification. Every report is written as if someone might read it later. Every delay is dressed up as necessary. Every decision is framed as proportionate. When you calmly point towards future explanation, you force professional tightening. So they tighten their reasons, then they tighten their reasoning leads to clearer recommendations, safer decisions, incremental movement, not dramatic change, but real change. But what not to do, and this is where people blow it. Do not demand outcome, accuse bias, threaten appeals, talk about corruption, personalize responsibility. Those things trigger defensive consolidation. The system doesn't collapse. It closes ranks. Today's practice task. This is important. Write this down privately. Identify where the case is currently frozen. Ask who benefits if nothing changes. Draft one question. References, processes, implies future explanation, contains no emotion, cannot be dismissed as hostile. If you can't imagine a professional safely ignoring your question, you're doing it right. Safely ignoring your question. The shift you're making today, you are no longer pleading. You are no longer protesting, persuading. You are structuring. Accountability without accusation. That's the difference between people who burn out in family court and the people who quietly get outcomes over time. Family court doesn't move when it's attacked. It moves when it realizes standing still might look worse. Day 22 is where you stop reacting to the system and start working with its fear in hindsight. Tomorrow, we talk about how professionals signal doubt without saying it out loud and how to read it before it's even written into your case. That's where the real advantage starts.